Um, this is 11.2, Migration Policy and the Nature of Work. My name is Johnny Kallas. I'm a PhD student at the ILR School at Cornell University. We have a busy and exciting panel to get to, so I'm going to get right to it. Each of our 4 presenters are going to have 10 minutes to present, along with our 1 discussant. And then we're going to have some time for a Q&A, hopefully. Please leave your questions in the chat. And I want to especially thank Kate Griffith for organizing and coordinating this panel. So thank you, Kate. And we're going to get started with Tristan Ivory. So Tristan is Assistant Professor of International and Comparative Labor at Cornell University's ILR School. Tristan, I'll turn it over to you.
Thank you, Johnny. I really appreciate you doing all the moderating. And again, as Johnny had said before, thank you to Kate for going ahead and organizing this panel. I really appreciate being on it. And so can everyone go ahead and see this okay? I just want to make sure that it's okay. All right, good. So let me go ahead and launch into this. So the title of this talk is The Shifting Context of Reception for Migrants in Japan from 1970 to 2010. This is based on a larger book project that seeks to look at sub-Saharan African migrants in Japan. And so this is part of the beginning of that larger manuscript that seeks to talk about what exactly changed in Japan over a period of time in contemporary history before the period that I start to look at contemporary migration to Japan. So let's go ahead and get started. So the central claims of this particular work are that the construction of Japan as an ethno-culturally homogenous country and this homogenous society, that's a fairly recent socio-political project. So when people tend to think about migration in Japan, they tend to think about Japan being very homogenous, but they tend to forget that that's been a very recent political project, a post-World War II project. So John Lee is, at Berkeley has done some work on this. And because it's a socio-political project, we need to kind of excavate exactly what's happening at the margins of that society with respect to migration. And so after Japan rebounded from its defeat during World War II, there have been 2 distinct periods of social and economic incorporation for foreigners. And there have been notable groups of foreigners in Japan during this time period. So in the bubble period from 1970 to 1989, this is when Japan's economy was expanding and there were plenty of opportunities for labor migrants, but there are legal roadblocks and indifferent or hostile society towards social inclusion. So if you could get to Japan and find a way in, you could make a lot of money, but you would never really be included. And then we have the lost decades period. So this is after the bubble burst in 1990 into the 2010. So at first people were calling the 90s the lost decade, but then this economic stagnation kept going into the present day, in fact. And so now a lot of scholars have termed this the lost decades. And so you see this contracting or stagnant economy, yet there's increased opportunities for human capital migrants. So people who are coming in order to gain some sort of increase in human capital, think degrees, think credentials. And so for those individuals, lots of increased opportunities, but very grudging acceptance and only of the right kind of migrants as permanent residents, so permanent foreigners on the part of Japanese society at writ large. We need to look at what's happening pre-1970 in order to get a sense of what's happening during these periods. So national membership went from nominally open and expansive during this imperial period, in which Japan was seeking to become a player on the international stage, competing with a lot of European imperial empires. And so in order to do that, there was this nominal open membership that was given to a lot of the imperial subjects. And then that went to closed and restrictive after the World War II defeat, or so retroactive stripping of citizenship rights. This homogenizing of post-World War II Japanese society was, again, as I said, retroactively stripped a number of Korean and Chinese subjects that were living in Japan of their citizenship rights and made them permanent quasi-citizens, permanent foreigners with special residence permits. The economic hardships during that rebuilding process of rebuilding the Japanese economy in the post-World War II period also helped to create this idea of a much more insular, inward-looking Japanese society. So by the time that full recovery was actually happening during what's termed in Japanese societies the golden 60s, there's little infrastructure or social will to increase immigration to Japan, or to even give any attention to the fact that there were still minorities living in Japan. So this table is basically giving you a little bit of a look at all the different ways to get into Japan if you were a migrant post-1970. So front door means legal, sort of on the face of it, immigration to Japan. Side door is things that are still legal, not necessarily termed as migration, but turn into migration in some senses. And then backdoor is things that are illegal or impermitted. And so you can see there's different categories of individuals: high-skilled, foreign-born Japanese individuals, people in the culture industry, through the front door, trainee students, and the side door, people that are low-skilled or, quote, unskilled and undocumented migrants through the back door. And you can see the different countries that people are coming from, the relative proportions, and then the sort of reception that people are getting in Japan. This is also a chart that gives you a little bit of immigration policy in 2010, the end of the period that I was looking at, and it's a comparison with some other countries of note. So South Korea being the closest country to Japan, then Germany, the UK, and the US. And so if you actually just look down here from average long-term visa length, whether there's low-skilled labor visas, the duration minimum for permanent residency, whether there's dual nationality for adults, whether you can reunify with family if you are a visa holder, Japan is very stringent. So it's a very limited environment that a lot of foreign migrants are coming into to begin with. This is just giving you a sense of how Japan looks stacked up to other countries. This is a little bit of a line chart that's showing you the relative populations of non-Japanese individuals in Japan since 1980. So as you can see, the blue line that's ascendant all the way to 2010 are Chinese migrants. So people coming from mainland China in particular. Koreans have traditionally been one of the largest non-Japanese populations in Japan since the beginning of the 20th century. They have been eclipsed by folks from China as of about 2007. And then you can see Brazilian, Filipino, Peruvian, people from the US, Africans, which I study as well. So during this bubble period, you had, so what was going on in the economy was that most jobs were at small firms. There was abundant low-wage work, but really few opportunities for highly skilled migrant workers. In the social milieu, there's extremely limited avenues for incorporation. Total assimilation was required, yet it was impossible and difficult for even well-placed migrants. For political, little appetite to pursue integration policy, but pressure from overseas governments and gradual shift in immigration to settlement policy. And then this race piece was white immigrants had an advantage. East Asian immigrants were discriminated against, but could blend in a little bit more. And brown, meaning folks from the Indian subcontinent and South Asia in general, or from Africa or Latin America, were generally disadvantaged. Gender, women were lacking lots of legal rights and standing. Men were seen as threatening. So what was changing during this last decade's period? You had a number of legal revisions to the immigration code. They expanded residence categories and substantial changes to the naturalization process. In the political field, you had conservative politics, a really brief spell of liberal politics, then back to conservative, official state multicultural policies, but not integration. Attitudes, there was this drift towards the idea that marriage migrants were okay, especially female marriage migrants, but labor migrants, especially male labor migrants, were not okay. And then this expansion of international educational programs actually created institutional areas for high-skilled migrants to actually incorporate into Japan. But the contracted low-skilled labor market actually did a disservice for unskilled migrants. So this result was a grudging acceptance of the right kind of long-term foreigner presence in Japan, the shifting migrant advantage, high-skilled gains, low-skilled losses, colleges and universities become site of immigrant incorporation, the incorporation of migrants as foreign populations, but not true integration, and this increased role for municipal and prefectural governments in terms of how individuals are incorporated in Japan, especially what sort of labor benefits might be given. So thank you very much. And any questions that you might have, I'd welcome towards the Q&A, or you can contact me by email.
Great, thanks so much, Tristan, and thanks for finishing just under time, covering a lot of information too. Thank you. So next we're going to hear from both Kate Griffith and Shannon Gleeson. So Kate is a professor of labor and employment law and the chair of the Labor Relations Law and History Department at Cornell's ILR School. And Shannon is associate professor of labor relations law and history, also at Cornell ILR School. I'll turn it over to you both. Thank you.
Great, thanks a lot, Johnny. So I'm going to get started, and then Shannon and I will kind of go back and forth a bit. Basically, we're going to talk today about one piece of a larger project that Shannon and I have together. So I wanted to give you a little bit of context on the larger project and then talk more specifics on this particular piece of it. So as Shannon, you can move to the first slide. So the thing that really is the seed of this project is this contradiction in we're turning to the United States, the U.S. context here from Tristan's international intervention. So in the U.S., there's this tension or contradiction between our immigration regulatory regime and our workers' rights or employment regulatory regime. And you see it most starkly when we think about people who are working in the United States and they're undocumented under immigration law. So they don't have particular protections under immigration law. They're not documented. However, they're working. And as the matter of workers who are providing labor, as long as they fit that definition of employee, which doesn't always happen, but if they do fit the definition of employee, they have particular rights in terms of wage payments, health and safety, protections for their collective action, et cetera. And so we have some people working in the US who are undocumented under one regime, so they're not protected, but they are protected under another regime if they fit the definition of employee. Because most of our workplace protections are provided because of the labor, and thus immigration status does not take those protections away. So Shannon and I are both very interested in this tension. We come at it from very different disciplinary backgrounds. I'm a law scholar and she's a sociologist. So we have different methods and different literatures, but we're both very interested in learning more about how immigration status affects workers' experiences. And both of us have done individual writing on that, but in this project we bring it together. And you can see here on this slide kind of the overarching questions are really, how does immigration status affect workers' experiences on a number of different levels in terms of wages, health and safety, access to jobs, et cetera. And so in the broader book project, we want to look at not just the binary of documented workers versus undocumented workers. A lot of the literature does focus on that binary. Our own writing has sometimes also focused on that binary. So we want to bring it into a broader spectrum by looking at another category of workers who are, we talk about them as having temporary status. So these are people who are documented under our immigration laws, but their documentation is just temporary. So they don't have a path to citizenship. They're allowed to work for a specified period of time and can become deportable. And so the broader project will look at how these different immigration statuses affect workplace experiences differently. So the slice we're biting off today is looking at just one group, the temporary protected status workers, and how that status affects their job stability. And I won't go into too much detail, but TPS, or temporary protected status, it's a humanitarian designation. The US designates countries as having TPS eligibility based on natural disasters or civil strife. Again, it's temporary, so there's no path to citizenship, but there is work authorization for this group. Okay, so with that, I think I'll turn it over to Shannon to talk about our methods and findings.
All right, everyone can hear me okay? Okay, great. So the approach that we took for thinking through the experiences of this category of migrant was twofold. One, kind of leveraging both the legal scholarship that Kate has, as well as work that I've done in terms of interviewing workers themselves. We started, and this is actually more a real iterative process. On the one hand, we looked at the legal documents and the administrative processes associated with temporary protected status, but we also were very much interested, rather than just looking at those documents, understanding how they played out in practice. So we did a series of interviews with workers themselves who had TPS. We're not going to talk today about the other two categories. We also talked to folks who have undocumented, who have legal permanent resident or citizen status. Today we're focusing on the TPS holders. But in addition to talking with workers, we also speak with advocates themselves. We made a conscious choice not to talk to employers for various reasons, including the fact that I think that requires a special effort that we weren't equipped for in this design. But advocates were really important, both in terms of worker advocates as well as legal advocates who were helping with the lawyering piece of this, because they often were liaising with employers who were getting perspectives about how employers too were having to navigate this bureaucracy, which we'll talk about. These interviews were in the New York City metropolitan area. Primarily what we're talking about today is individuals who are either in Brooklyn, largely for the Haitian population, and New Jersey and Long Island for the Central American population. And we're continuing to do interviews with the other two categories as well, but we're going to focus on these today. And we did a series of organizational interviews, both in New York City, as well as legal scholars who have been focused on TPS nationally. You can see here in the table kind of the breakdown. It's a fairly even gender distribution. We're not going to talk about this here today, but we do think that there are some gender dynamics, largely having to do with occupational segregation, I think, and other things. But here, I think it's just important to note that we have good representation of both people identified as men and women. And you can see that the kind of residential segregation of each of these populations represents where we were going to talk to them. Again, though we're not going to focus on this as much today, these are largely, and because of the focus of the study today, we're focusing on what we think of as low-wage workers in home care, construction, and restaurants. Were kind of three of the largest areas, though not by no means the only ones. So I want to highlight two pieces of our findings, just to kind of give you a sense of why we were interested in thinking through the temporary protected status category. TPS individuals actually only constitute about 300,000 to 400,000 individuals. And one thing we haven't mentioned is that TPS is in the process of being phased out by the Trump administration. We'll see with the various court decisions what will happen. But we're interested in TPS because we think that it represents not only a broader category of temporary worker, non-guest worker temporary worker whose visa or status is not tied to the employer, but also we're interested in this category because through many of the failed congressional discussions, their work visa looks a lot like what we are likely to move towards if there ever is a comprehensive immigration reform. In other work, we kind of talk more explicitly about the comparison to guest workers, but the thing to highlight here is that whereas when we talk about the particular vulnerabilities that guest workers have is focusing on the fact that their status is tied to their employer, oftentimes the temporariness of their visa is overlooked. And here I think TPS holders help us illuminate. And with these workers, we heard both from advocates as well as workers that the employment process itself was really hamstrung by the temporariness of this status. And so advocates talked about, for example, how workers were simply unable to even say how long they were going to be there. And unlike undocumented workers who either have false papers or no papers at all, here there's this clear expiration date on the visa or on the employment authorization document, technically not a visa. And workers themselves also talked about the challenge of having to go through constant renewals. And so the temporariness is tied to a very hefty fee that they have to also pay in order to renew, and the uncertainty that comes with that. And so we were interested in kind of understanding not only how immigrants themselves were navigating this, but also employers. And so we talk on the paper about how this creates additional risk that employers who have a free market of labor to turn to often would pass over temporary protected status workers. And the second dynamic here, which I won't spend too much time on, but just to highlight, is that the bureaucracy itself that both employers and workers are navigating is both tied into an immigration enforcement regime, right? So workplace enforcement is one of the largest kind of sites of immigration surveillance, with consequences not only for workers, but also for employers, which accentuates the risks and the costs that they're taking on. And so advocates talk about how they have to interact with this enforcement wing of the immigration state, often being at risk for audits, and HR companies, but also just employers themselves, even in small businesses, really having to think through whether or not these workers are worth the hassle. And the second piece of this, aside from employers having to think through whether or not they want to run the risks of being out of compliance, is this disarticulated nature of the work authorization. And so whereas Congress and the president might make broad announcements about the program, that is announced in some kind of lengthy bureaucratic document called the Federal Register, but that doesn't necessarily catch up to the U.S. Citizenship and Immigration Services, which authorizes the employment authorization document. So even though someone very much might be in compliance, they don't have the paper to show the employer. And so again, we talk about how this creates costs for employers as well as for workers. So I'm going to turn it back to Kate now.
Okay, and I'm guessing I have less than a minute, right, Johnny? So let me just make it very quick and leave the rest of discussion. So 2 take-homes. One is just because these workers are documented, right? They have some form of documentation. It does not mean their work is not precarious. So there's still some precarity driven by the immigration regulatory regime, even for documented employees. The other is, and as Shannon just spelled out in the findings, the role of employers is key here when we think about the mechanism and the relationship between immigration regulation and precarity. The way that employers are treated by immigration law matters. Most of the research and focus is how employers are privatized deputies. They're enforcing the law. They're scaring workers. They're part of the state machine. In this research, focusing on TPS, we see that employers are also targets of immigration surveillance and regulation, and that affects their behavior, right? Not just when they're playing the part of the state. I'll end it there.
Great. Thanks so much, Shannon and Kate. And I just want to remind everybody in the audience, I encourage you all to post questions or comments in the chat section so we can have a short but thought-provoking conversation after. I'm now going to turn this over to Ben Rissing. Ben is an assistant professor of organizational behavior at Cornell ILR School. Ben, it's all yours.
Thanks so much. The title of my study today is To H-1B or Not to H-1B. And in particular, I'm going to be looking at dynamic sources of bias that might be based on decision makers' experiences and events as they evaluate potential H-1B temporary work visa applications in the United States. So it might be unsurprising that government agents in the US treat immigrants differently based on their country of birth. So here we have some great studies in the last few decades that have suggested that government agents might disproportionately search for legal violations based on, for immigrants based on their country of birth. So motorist inspections, you can think about employer raids, also secondary screenings at border crossings. But we've also seen that immigrants might be excluded from work opportunities based on their country of birth as well. Here there's been a lot of attention to explicit and arbitrary travel bans, but also refusal to grant things like refugee status, and also government agents' explicit denials of work authorization requests. So one of the things that I'm going to be examining here is what might explain government agents' both variable scrutiny for immigrants and also their denial decisions based on immigrants' different countries of birth. So for this work, I'm going to be analyzing U.S. Citizenship and Immigration Services agents' assessments of H-1B temporary work visas. In particular, I'm going to be relying on Freedom of Information Act data detailing the sequential judgments of these USCIS agents over a period of 20 years. So a long panel of data to understand how their biases or their judgments might change with time. Using this setting, I'm gonna analyze whether or not agents' personal experiences evaluating these visas or their exposure to negative events might disproportionately shape their preferences towards immigrants from different countries of birth. So first off, in terms of dynamic bias, there have been a number of theories that stress the role of experience. So specifically, through their repeated assessments of individuals belonging to different groups, decision makers may update their attitudes regarding said groups over time. This is a core mechanism within statistical discrimination in theories of economics. In psychology, this is related to the bookkeeping model of stereotype updating. And within OB, we sometimes see this in learning models. So this leads to this first hypothesis that I'm going to test. When assessing a new applicant, a decision maker who's denied a larger quantity of applicants from the same country of birth in the past will be more likely to both scrutinize this new applicant and also deny this applicant. At the same time, when assessing a new applicant, a decision maker that has approved a larger quantity of applicants from the same country of birth in the past, they might be less likely to scrutinize, less likely to deny future applicants, again, from that same country of birth. Now, there's also been a parallel body of literature that's highlighted the role or potential role of negative events in shaping dynamic biases. So here, decision maker bias might be shaped by certain, say, highly public negative shocks, things like crimes, things like attacks that might be associated with members of select groups that can predominantly shift attitudes regarding members of, or preferences, expectations regarding members of these demographic groups. In sociology, this is related to theories regarding stigmatizing events. In psychology, the conversion model of stereotype updating. Minority threat is another sociology literature that relates to this. So this suggests that when suggesting a new applicant, a decision maker exposed to a larger quantity of, in this study, prior fraud determinations targeting applicants from the same country of birth, that decision maker might be both more likely to scrutinize this new applicant, but also more likely to deny them out of hand. So in terms of a research design standpoint, these USCIS visa adjudicators, they randomly get assigned visa cases, and then they sequentially evaluate these. It's their job to determine, okay, do I need more information if I'm going to make this decision? And also, should I approve or deny this visa request? So if we imagine this visa adjudicator here, this is their first day of work, they get a queue of visas to evaluate. They might work their way through these first 4 cases, so approving some, denying others. When they get to this 5th application from country B, they've approved 2 applicants from country B in the past, and this might begin to shape their expectations regarding the likelihood of approval for this group. Now, another example here for testing the second hypothesis is within their local USCIS office, there might be an announcement of a fraud case that was uncovered targeting an immigrant from country D. And this broad announcement, this negative shock, again, might impact their attitudes or preferences for immigrants from this 4th country here. So essentially, I'm going to follow these sequential judgments for all 8,192 USCIS agents employed who evaluated the population of H-1B work visas over a period of 20 fiscal years, detailing 6.3 million visa adjudications. So I have Freedom of Information Act data detailing the population of approved and denied applications during the window from 1996 to 2016. For immigrant workers, I have data on their country of birth and their human capital. For employer, the name of that employer, the type of organization, their industry. For occupation, the annual salary, job title, and location of work. For the application, the date of receipt, the specific evaluating USCIS agent's ID, so the person who makes the judgment, and the service center where they're employed. For outcomes, I know whether or not the agent made a request for evidence, similar to an audit. They want justification for the claims in the application, and then whether the application was approved or denied. Applications are evaluated in one of 5 service centers throughout the United States. The real big important takeaway here is that the majority of these are evaluated either in California or Vermont. So this is what things look like inside the California Service Center. You can see it's kind of a cubicle farm, big paper pushing environment. This is the inside of the Vermont Service Center, so not that dissimilar in this regard. Just as a quick overview of the evaluation process, an application gets assigned to a USCIS agent. they may then look at it and elect to scrutinize the application. Is more information necessary? They then, if they collect new information or not, they evaluate the application, resulting in either approval or denial. So these are my results from a linear regression model predicting agents' application scrutiny. That is an RFE, request for evidence. Are we going to collect more information, or are we going to rely just on the application itself? I should note that these models are consistent if a logit or probit is used. So the first model includes only independent variables that are related to agent's experience. So the natural log of an agent's prior same country approvals and prior same country denials. Model 2 adds event-based independent variables, specifically the natural log of the prior same country frauds that were uncovered in an agent's CIS office during their tenure, these essential shocks. Model 3 includes both of these independent variables together, and then Model 4 further includes human capital controls. I should note that these models are relatively conservative in that they also include fixed effect controls for the agent making the decision herself or himself, and also fixed effect controls for the country of birth for the immigrant. So in this Model 4 over here within the red box, you can see that as an agent's prior quantity of prior same country approvals increases, the likelihood that they scrutinize an application decreases. Similarly, if the agent, as the quantity of prior same country denials increases, they're more likely to scrutinize the application. If they're exposed to more same country frauds, again, they're more likely to scrutinize that application, indicating that within the same person, this notion of bias or preferences can shift over their tenure. This next model predicts denial outcomes, and the structure across these different models is the same as the prior table. So as we get to Model 4 over here, we can see that a 1 unit increase in the quantity of prior same country approvals decreases the likelihood of denial by about 1.5 percentage points. A 1 unit increase in the quantity of prior same country denials increases the likelihood of denial by a little less than 2%. And there's no statistically significant difference in denial outcomes based on prior fraud events that an agent might have observed. So in terms of big takeaways here, scholars have noted that little is known about the factors that might influence regulatory agent decision-making. And this is one setting that highlights how external actors to an organization or employer, here government agents, can shape employment within firms. And notably, while we've had lots of studies that emphasize inequality and bias as being largely a static construct, employers or decision makers might have certain preferences. This shows how bias can be more dynamic in nature. So the findings stress that prior evaluation, both experiences and exposure to negative events, can shape subsequent scrutiny when we're going to, say, investigate the claims in a visa application. Also, prior evaluation experiences notably shape subsequent denial, although there's less an effect of exposure to negative events on subsequent denial. These results broadly emphasize the role of an individual's direct personal experiences in shaping bias, rather than one's, say, indirect exposure to things like events, say news stories or coverage of say, negative shocks in terms of influencing outcomes. So with that, again, I appreciate everyone's time here. I look forward to comments or feedback as we go forward. Thanks so much.
Great, thank you so much, Ben. And to hear more about the H-1B system, we're going to turn it over to Laura Carver. Laura is a PhD student in the Department of International and Comparative Labor, also at Cornell's ILR School. Laura, whenever you're ready, all yours.
Okay, thank you. Can everyone see this? Okay. So the paper that I'm presenting today is called Mixed Signals. And my goal in this study is to test whether lawyers systematically affect the type of compliance that organizations adopt in response to new laws. And to do this, I'm going to be evaluating how employers of skilled immigrants on H-1B visas respond to changing regulatory guidelines under the Trump administration, and whether or not lawyers influence these responses. So I'll start with just a very brief theoretical motivation for this paper, and then I will jump into the setting and analysis. We know that new regulation is very often ambiguous, which lends itself to multiple possible interpretations. So organizations that are the subject of this regulation may engage various meso-level actors to try and help them interpret the regulation and come up with what they think is an acceptable compliance response. One of these group of actors, of course, is lawyers. With that being said, we don't actually know a lot about the positive role of lawyers in this process and whether they, for example, encourage companies to adopt some forms of compliance, but not others. So to develop hypothetical predictions about the role of lawyers in this process, I'm going to draw from a couple competing theories of legal professionalism that offer insights salient to a study of organizational compliance. So the first of these theoretical accounts essentially positions lawyers as wardens of the public good. According to this perspective, lawyers play a key informational role. They communicate the substance of new laws to their clients, and furthermore, they're professionally socialized to uphold the letter of the law. And this leads to my first hypothesis, which is that when organizations use lawyers, they're going to be more likely to demonstrate a literal compliance response to new regulation. In other words, one that represents a good faith attempt to comply with the substance of the law. A competing account, though, argues that lawyers may be compromised by their financial ties to their clients. So according to this perspective, lawyers may prioritize the needs of their corporate clients, even if this comes at the expense of strict adherence to the law. And this account suggests that lawyers actually help clients architect creative or cosmetic compliance responses that are more superficial than substantive. And this leads to my second hypothesis, which is that when organizations use lawyers, they're going to be more likely to employ a creative compliance strategy in response to new regulation. And to test these hypotheses, I'm going to be evaluating H-1B application data. And I think Ben already provided some helpful background on this process, so I don't want to spend too long here. But the point that I want to make here is that there's a two-stage process to every application. And the first stage involves the employer filing what's called a labor condition application, or an LCA, with the Department of Labor. And on this LCA, they need to list details of the position, such as job title, location of work, salary, notably, and as well as some identifying details about themselves, the employer. And then once this LCA is certified, it can be submitted with other supporting documentation to US Citizenship and Immigration Services, which is the agency that makes the final yes/no determination on the visa. Some brief context on our current political moment and how it's affecting the H-1B. As I'm sure you are all aware, the Trump administration has taken a relatively hostile stance towards immigrants in general, but they've also taken some steps that target the H-1B visa specifically. So Donald Trump issued the Buy American, Hire American executive order in April of 2017. And while the language that this order contained is pretty broad, some lawyers have argued that this provided a pretext necessary to increase scrutiny of H-1B petitions. And in fact, H-1B new visa application denials have gone up about 14% between 2016 and 2019. All this to say, this has created a pretty extreme climate of uncertainty among the workers themselves, as well as H-1B employers who find themselves in shifting regulatory ground and trying to maximize their chance of getting a favorable visa adjudication. And rather than make formal statutory change, the administration has periodically issued memos or updated guidelines for evaluating visas on USCIS's website. And in one of these memos, which was issued in March of 2017, USCIS called into question whether applicants with the title computer programmer really deserved the H-1B visa. The text of the memo obviously implies that USCIS is making some change to their evaluation policies for computer programmers, but employers still need to interpret this memo and decide how, if at all, they want to respond. And I argued that employers have two primary proactive responses at their disposal to this memo. First, they could increase the wage level that they offer computer programmers on subsequent applications. This is something that USCIS explicitly references in the memo as a valid way to demonstrate the specialty nature of the position, with a higher wage presumably reflecting superior human capital in a more complex position, and thus someone who is more deserving of the H-1B visa. And I'm therefore considering this a literal response to the memo's content. On the other hand, employers could just stop calling subsequent employees computer programmers. This is obviously not a strategy that USCIS recommends in the memo, and I'm considering this a creative response to the memo's content. And my data for this analysis comes from the Department of Labor. It contains the population of LCAs that were filed for IT positions in a 2-year period bracketing the memo's release. Within these applications, I'm able to delineate those that were filed with the assistance of an attorney and those that companies chose to file independently. I have 2 dependent variables. When I'm testing literal compliance, I'm going to be predicting whether or not the wage level listed on the application is at or above the local occupational median. And when I'm testing creative compliance, I'm going to just be predicting whether or not the application uses the SOC code for computer programmer. My main independent variable is another indicator for whether or not the application was filed after the memo came out. And then I have a spate of control variables, including the type of application. So for example, if it's a new visa versus an extension of an existing visa, the state where the worker will be employed, whether or not they're full-time, employer industry, as well as a measure of the total applications filed by the employer, which I'm going to be using as a proxy for the firm's size and financial resources, as well as their informational resources and familiarity with the H-1B system. My first set of models is predicting whether or not the wage on the LCA is above the local occupational median. And I've divided the applications into those that are filed with the assistance of a lawyer and those that companies filed independently. And I'm running the regression separately for these 2 groups of applications. My 3 independent variables are, again, the post-memo indicator, another indicator for whether or not the application was filed for a computer programmer, and an interaction of the 2. And this is essentially a differences in differences setup. So I'm interpreting the interaction term as the effect of the memo on the likelihood that an applicant or a computer programmer will be paid above the local occupational median after the memo relative to a non-programmer. If you turn your attention to just the lawyer filed applications here, which are shown in the second column, the coefficient of the interaction is positive and significant, which indicates that programmers are about 3% more likely to be paid above the local occupational median after the memo relative to non-programmers. For independently filed applications, however, this coefficient is actually slightly negative, but pretty close to 0. And a post hoc test indicates that the observable difference in these coefficients is statistically significant. So collectively, the results of these models provide evidence in support of hypothesis 1, which is that, again, that when organizations use lawyers, they're going to be more likely to demonstrate a literal compliance response. In this case, increased wages. My second set of models is predicting the likelihood of the title computer programmer appearing on an LCA, with the independent variable here just being, again, this post-memo indicator. Again, I'm running these models separately for lawyer-filed and self-filed applications. And lawyer-filed applications are approximately 6% less likely after the memo to use the title computer programmer, compared to about 19% less likely for applications that companies filed independently. And again, a post hoc test shows that this observable difference in coefficient size is highly statistically significant. And this actually provides evidence in direct opposition to hypothesis 2, because in these models, applications that companies filed independently are actually much more likely to demonstrate a creative compliance response, just dropping the use of the title programmer relative to lawyer filed applications. And I've conducted a series of robustness checks to rule out alternative explanations for these results and more systematically deal with the potentially endogenous decision to use a lawyer on a given application. I don't think, given the sign I just saw, I don't have time to talk through these right now, but I'd be happy to talk through any questions that people have during the Q&A. And to briefly conclude, these analyses suggest that lawyers do moderate organizations' responses to new laws. When organizations use lawyers in my study, they're more likely to employ a literal response and less likely to use a creative response. When it comes to next steps, I'm hoping to extend this research by probing some intra-professional differences within the legal community that may affect the form of organizational compliance that they advocate, notably level of lawyer specialization, in this case, specialization in the field of immigration law. And with that, I will wrap up. Thank you.
Great, thanks so much, Laura, and thanks to all 5 of our presenters for some really great presentations. I now just want to turn it over to Maite Tapia for some discussion. So Maite is assistant professor at Michigan State School of Human Resources and Labor Relations. And I'll turn it over to her.
Thank you, Johnny. Can you hear me all? Okay, great. So first, thank you for these great presentations. I'll go over each one of them with some questions, but no need to respond to any or all of my questions, though, as people from the audience might have some more comments as well. So I'll start with yours, Tristan's. I'm very excited about your book project on migration policy in Japan. And while maybe more and more IR scholars focus on migration, the specifics of looking at migration in Japan and focusing also on sub-Saharan Africans in Japan, I would say has definitely been overlooked. So some of the questions I had were, who are the main actors that you're focusing on, or what are the key alliances in setting up the regulation? What has been, if any, the role of labor unions within that? Was there any pushback or resistance from migrants themselves, from others? So kind of what are the actors that you focus on? And then another question is, to what extent is this substantially different from what is typically, from what we know in the West, in the US or the UK, and if so, why you think that is? I don't know if it was in this slide session, but in the previous ones that I got, you talk about how sub-Saharan African middle-class migrants, when they arrive with similar backgrounds in Japan, they're kind of sorted into two different and unequal tracks of skilled and unskilled. And I was wondering if you could elaborate on, perhaps not in this session, but later on or whatever, why was that? Is that based on their country of origin within the SSA region, or other reasons? And then finally, just a question about kind of your methodology in terms of the book project. It seems that from one side, you have taken kind of a from the ground up view, and just as Shannon and Kate have done, kind of looking at the migrants themselves. And so I was wondering what the process has been for you to study this phenomenon. So again, very interesting work. Thank you. So then the second presentation by Shannon and Kate, this is either already out or forthcoming in the journal Law and Social Inquiry, and I highly recommend it. It really gives you a sense of the role of the state in regulating immigration and controlling of employers through coercion and bureaucracy. So it's an interesting take on that. Employers are not just perhaps taking part in kind of a state deportation machinery, but they're also a subject of the immigration state. They're subject to penalties and costs. So here again, it's great to see kind of that from the ground up view, as you say yourself, and hear from the workers themselves. And their focus on migrant workers with temporary protected status and their issue of employment security, or the extent to which they can get or keep a job. So some of my questions, these will obviously go beyond the scope of this paper, as it's already published, and again, it's a great paper. So one question I had was, while employers are subject to states controls, to the state's controls and penalties, at the same time, I did wonder, though, what motivates employers then to hire TPS? Are there differences across sectors? Are there more actors involved? For example, these advocates that can liaise with the employers and will push them to go one way or the other, kind of going to Laura's point or of the role of lawyers potentially, even though it's a completely different set of migrants. Second, there were also a relatively large amount of workers that had attended at least some college in your sample. Are there any ways for them to upgrade to better jobs? So in other words, what's the way out for TPS workers? What's the next thing? And that kind of comes to my last question here is, what kind of reforms do you think are needed to improve the employment security of TPS workers? Or should this category not exist at all? As you said, it's being phased out currently by the Trump administration. So what are the alternatives? Some have argued, for example, to abolish ICE. And ICE is indeed one part of the state apparatus that exacerbates precarity, but what are your thoughts on that? Then the third paper was by Ben Rissing. Again, a great setup, H-1B or not, and looking at the role of agents in scrutinizing more or denying migrating applicants. It's really a great research design and setting with impressive data capturing over 8,000 agents, over 6 million applications essentially. So these are some of my questions or comments. So your findings show that when assessing a new applicant, agents that have denied a larger quantity of applicants from the same country of birth are more likely to scrutinize or deny the new applicant, right? So maybe this is already, maybe I missed it, but I do wonder, so why do they deny them in the first place? I understand it's in line with kind of statistical discrimination, but what are kind of the underlying mechanisms here? Could the reason be for the denial that there have been negative local shocks or crimes associated with these members in the first place? So in other words, could it be that the direct kind of personal experiences are a result of the indirect exposure? Second question I had is, what can you tell us about these fraud cases? How are these announcements made, and are there any degrees of fraud? And also then, to what extent could you potentially test whether news events, for example, if you think leading up to 2016, like presidential candidate campaigns at the time, could that affect decision-making of agents? Do you have any demographic data on the agents themselves? Maybe you do, and I might have missed it. And then finally, I think your theoretical contribution in terms of the dynamic bias is very important and interesting. And I wonder how it builds kind of on the previous bias literature, and if you can explain the significance of that. So then last but not least, to Laura's presentation. So that one is on the role of lawyers when helping employers navigate new regulation. So Laura is asking, will they stick to the letter of the law, or will they become more creative? And she finds that they stick more to the letter of the law and are less creative than if the employer worked independently. So also here, a very clever research design and great access to the data. So my question is, first, I did wonder whether the wage level is actually a literal response, or could this be also just being creative by the lawyers? So is this acting in accordance with strict interpretation of law, or is this about saying we're just going to put on that they earn more and kind of signaling a higher complexity of job duty? Second question I had is, what was the percentage in general and the decline in these LCA applications after the memo, and what are kind of your thoughts there? And then finally, it seemed from your data, if I understood it correctly, that employers independently are more likely to change title when they fill it in themselves than when done by a lawyer. And so I was wondering here what the costs or penalties were for getting caught, and whether there's a difference between lawyers and employers, or what your thoughts are. So again, these are my comments. There are many, and you don't need to respond to any of them if you don't want to. We can, leave it to other participants or attendees to chip in here. But again, excellent presentations, and thank you. Thank you.
Great. Thanks so much, Maite, for those really helpful comments. I think there were a few questions to each participant, so maybe what we can do, we only have a little bit of time, but maybe each person can take 90 seconds to respond to one of those questions. And Ben, I'll just point your attention to, there was a question to you specifically in the chat if you want to integrate that as well. We'll start in the order in which we went in. So Tristan, go ahead.
So thank you, Maite. I really appreciate those questions. They're very well conceived, and definitely if we can have a chat at some other point in time, I can go ahead and answer them in more depth. I think the kind of most pertinent question that you were talking about was sort of the role of like how are things different than the United States or Europe? And one of the main differences is that although there are trade unions, they actually play a very muted role. The sort of dominance of large businesses and business kind of advocacy groups is pretty total in Japan all throughout this period. So a lot of the sort of laws that are decided are even more business friendly for large businesses than you might see, especially in Europe, but even in the case of the United States. I think Japan kind of operates on a very kind of business-friendly end of the spectrum, even a little bit more than the United States in terms of laws for the incorporation of immigrants. And it just because there's also the populace, which actually doesn't have an appetite for increased immigration. And that's one of the reasons why immigration rates have been kept very low. But the sort of suppression of rights for immigrants that are coming to Japan as far as job protections or agreements is pretty diffuse. So people can get to Japan in some sense, but once there, they really don't have any protections at all in terms of being exploited. And that's one of the things that a lot of unskilled laborers have found out pretty directly in Japan. Thank you.
Thank you, Maite, for your really helpful insight. Just two quick things. I do think that it's harder for us to understand whether or not advocates themselves are on a large scale having an impact. I do think we have a best case scenario having done this in New York City, where there's a real concentration of legal advocacy. But I do, one of the insights we have is actually from an ILR event we had a hospitality roundtable, and there it was very clear, at least in the restaurant and the hotel industry, that there has been a level of kind of industry knowledge developed around how to handle immigration enforcement, even to specifics of TPS and renewal. So I think whether or not it's direct or indirect kind of consciousness raising, whether it's worker advocates or counsel that employers are hiring and how that diffuses down to even smaller businesses, I think that some of that does matter. And I'll just say really quick, part of our goal is to look at the possibilities for mobility over time. And some of the work that we've done in other papers, we've asked people to speak retrospectively about how once they got TPS, many of them are previously undocumented, how that mattered for mobility. And we should be focusing specifically on those with some college degree. I think that's a great question. But I think what we found is that, at least with the question of are people experiencing mobility once they have TPS, that some folks are getting into perhaps what we think of more formal sector jobs or more stable jobs, but those are usually lateral in terms of mobility within an industry. And so they might now be working for a temp agency that does home health care rather than doing kind of informal care work. And so I think maybe focusing on that subset of folks who have the human capital might be a good insight into that. So thanks. I think Kate was going to say one or two things real quick.
Yeah, I'll just briefly talk about the policy question that you posed. I think the most far-reaching policy implication, this is very far-reaching, meaning unrealistic, is to take employers entirely out of immigration regulation. It's problematic for them, it's problematic for workers. And also to consider really scaling back temporary statuses. So if people are working in the United States and needed, there's some path to legalization, ultimate permanent status would also be a huge improvement in terms of reducing precarity for workers. The more doable, shorter reaching things are the government needs to sort of fix the documentation process, help employers understand what documentation actually is suitable so that there isn't confusion when somebody who has TPS is actually renewed, but they don't quite have their card yet, that an employer can keep them employed. So just sort of the bureaucratic fixes are more immediate policy implications.
Okay, I think I'm up. So first off, Maite, thanks for all of the questions and the engagement with the study. You first asked about kind of baseline conditions. What could start some of these dynamic processes relating to H-1B evaluations? Part of the models that I run control for key kind of qualifying aspects of an application, things like how much education a person has, what types of jobs, whether they're specialty occupations. And these are the types of things that are designed to influence whether an application is approved or denied. And it could just be random luck of the draw. The first application from country X that an agent evaluates might happen to fail the educational requirements for a job. And this can, for instance, shape subsequent evaluations. So that could be part of this. You also you asked about how fraud cases could be communicated. USCIS is rather big on conveying to its agents these cases in which there are fraud determinations. They put up big posters in their different service centers. They also distribute emails that describe the conditions of the fraud event itself. They're relatively infrequent, but one approach could be to code with greater granularity features of those sorts of frauds. You also mentioned the possibility of coding in news events. I like that idea a lot. I think one of the challenges therein is whether or not an agent is necessarily aware of said news event. And so I think it could be possible to code all of that in, but an agent might not be aware of it to the same degree that uncovering a local fraud event is something that they're much more likely to be aware of. I would also note that, so I had a comment in the chat from Dongwu who asked about political climate between the US and other countries. I think that that's definitely something that could be coded. It's also interesting because it could be time variant during that 20-year period. I wonder if any given country's relationship with the United States might be sufficiently variable during that period that there'd be enough variation. For some countries, I'd imagine yes, but for many, it might be more static. The last thing I would note is perhaps one measure of that is in some of my other work, I've coded for tweets from the president with regards to certain countries and immigration climate. And generally there are, after the president tweets about immigration in a negative way, immigrants from associated countries are a lot more likely to voluntarily withdraw their applications. So there could be something of a knee-jerk reaction in that regard. So thank you very much.
Okay, I'm gonna try and be super speedy because I know we're over time. Maite, thank you so much. I think the first question you raised is really a good one, and about whether or not raising the wages is a literal compliance response or also constitutes a creative response. My answer to that would be the stated intent or objective of the Trump administration has been to prevent potential wage undercutting of Native workers. And that was, I think, the logic behind the issuance of the memo in the first place. And in this sense, the administration is kind of telling employers to put their money where their mouth is when it comes to hiring workers at a given wage level. So I think you could argue that the observed increase in wages that they offer is a correction and they were being underpaid before. But nonetheless, I think the very fact of increased wages are kind of addressing this underlying concern that motivated the memo in the first place from the administration. You also asked about the percentage decline in apps overall. So the year following the memo, there were about 4.6% fewer LCAs and 59.5% decrease in the number of LCAs filed for computer programmers. So there's a pretty stark contrast there, but I think the overall, there's been noted among immigration lawyers that applications for H-1Bs are going down given the increased rate of denial and the kind of poor rate of return on the application process. And then in terms of, do they face any repercussions for potentially changing the title nominally and not changing anything else and getting caught? I think the biggest risk they bear there is just having the visa be denied out of hand. Although USCIS agents aren't really in a good position to evaluate the job characteristics of a lot of these IT positions because they're so specialized and whether or not that corresponds to a specific job title. That being said, if there's some overt change, like, hey, this person was a computer programmer before and now you're saying they're an application architect, that might raise, if it was an extension of a visa, that might raise some red flags and increase the likelihood of denial. So I think that's the main risk they bear there.
Great. Thanks, everybody. This was a really great session. I hope we have more sessions like this in future LERA meetings, and hope to see you all soon. Thank you. Stay safe.